I'm going to take them in reverse order due to the fact that we got a lot of members that are down in the Appropriations Committee meeting right now. They'll be up. We should have a relatively short bill, House Bill 530. Representative Burchett is carrying the bill. He has asked for Representative Matt Reeves to present it on his behalf. If you will just take that podium and kind of run through it. I don't know, Representative, how familiar you are with the original version. There's just a couple of very minor tweaks in here. Or have you reviewed that?
I have. Senator Cowser, to members of the committee, good afternoon. Here to present House Bill 530. This is legislation concerning the Apex Doctrine regarding depositions of high-ranking corporate or government officials. This bill was in response to a court decision. There were extensive discussions and negotiations with various knowledgeable parties who were affected by the court decision, and this legislation had a lot of scrutiny and passed through House Judiciary and the floor. We believe this is important for both litigation of large civil cases as well as the business climate in Georgia. Every word in the bill is important. The House passed LC 44-2300. I believe there may be a proposal or a substitute, LC 44-2378S, and so to highlight differences in what the House passed and what may be proposed, the House passed language on line 43 of the proposed substitute. After organization with, the House had unique and extensive scheduling demands and responsibilities of the executive. And then on line 44 of the substitute, any other large and complex organization. That was on line 44 of the House, or line 45 of the House version. So
our substitute changed two words.
Took out
unique only as to scheduling, and took out complex as to the organization.
Unique and complex, correct. And we would ask you to leave those in. That's the request. We understand this is a Senate committee that's reviewing it, but we do believe those words are important and are the product of extensive discussions regarding this important matter.
That we weren't involved in, by the way. The Senate was not engaged in those discussions. On those
definitely
words.
The parties in interest were with the majority whip.
Our committee, Mr. Whip, all right,
There,
our committee is relatively familiar because we had Senate Bill 200 that passed out of this committee that Justice Blackwell had prepared, dealing with the same subject matter, a little more stringent protection for business. He copied the Florida statute that is a very business-friendly state. I think we understand the concept. Mr. Whip, if you would just sort of run through, you have seen, I think, the two changes that we had in our committee sub on the unique and the complex.
I have. Yes, sir.
If you would just sort of refresh my group here, tell us the purpose of the bill, what it addresses, and how it goes about doing it, and then we'll talk about the two small changes and see how significant they are to you.
There's currently in response to some litigation that's being had with some large corporations. GMC is one of them, and the Buchanan case is what we're trying to address here. Essentially, the issue is that whether or not a CEO or high-ranking official should be required to give a deposition if they don't have unique knowledge. So there's two sides to the story here. The high-ranking officials or the officials are saying that you shouldn't bring me in for a deposition because I have to run this large corporation or this large department if I don't have that unique knowledge. And on the other side, the folks that are seeking the deposition are saying that we do need this this deposition, and even if you have the unique knowledge, we need you here to give it because you have a special knowledge of whatever they're seeking to get. So what we've done here is we've gotten both parties here involved under the Gold Dome in our conversations, both the folks that are proponents for Apex and the folks that are opponents of the Apex, and we've sat them down and we've worked out a deal to where no one is absolutely happy here. You know, one group wants to go farther than the other group. And so I've been told if you get to a point where everybody is sort of unhappy, then you may have struck just the perfect balance here. So these two words you're talking about, I think that it's a three-part test the way that it's structured in the House. You've got to walk through whether or not you're an officer. All right, and in the definition, the words that are of concern of the Senate Regulated Industries Committee are unique and complex. So let's start with officer. The definition of an officer says that it is a current or former high-ranking officer of any of an organization with unique and extensive scheduling demands or responsibilities. So to me, if we just break it down by the elements, we're looking at unique and extensive scheduling, and that'll determine whether or not you even qualify as an officer, right? So we're trying to narrowly tailor this legislation so that we're only addressing those high-ranking officers like GM CEO, Ford CEO, the department head of, say, the Georgia Department of Revenue, Georgia Department of Ag. We're trying to narrowly tailor it so we only capture those folks without making it too broad so that we capture, let's just say, the CEO of someone that runs a hot dog stand. And so we want to say that it's both unique and extensive in your scheduling demands. I think that's, if you just take the regular meaning of the words, it's not a really hard test to determine whether or not it's both unique and extensive. I could say, for instance, the chairman's schedule is unique to mine. That's a pretty easy test to get past.
I mean, I get the unique knowledge, but unique scheduling, does anybody, I mean, everybody's schedule is different. What would make a scheduling problem unique?
Well, I wouldn't say that it would be a scheduling problem, but I would just say that this is a two-part test here, right? You need unique and extensive. So we can just say extensive, and it's just more broadly tailored. Unique is, I mean, I can make an argument either way, Mr. Chairman. I can argue that my schedule is unique to anybody else's in this room. We can also argue that my schedule is not unique as it pertains to each House member, or your schedule is not unique as it pertains to each chairman of the Georgia State Senate. So you can make an argument either way. It's going to come down to the discretion of the judge. It's going to come down to what the judge decides, whether or not you're an officer based on this definition. I think that the two-part test, unique and extensive, constrains it versus makes it more broad. I mean, if we just say extensive, then you only got to get past the extensive portion. So I have a...
Why don't we just change it to say a busy schedule? I mean, nobody in communication says, oh, my schedule's kind of unique this week. I don't get the why that adjective is so important to the Georgia trial lawyers. I just fail to see what unique means. Why not just say, hey, I got a heavy schedule because I'm running this corporation or this department or this agency.
Well, I think
Like
ultimately
we're
it's
fighting
going
over semantics that are not that meaningful.
I agree. So
we're fighting over it.
I would say, then why take them out? If we can say, if I can go to the judge, Chairman Cowser, and say, Pro Tem Kennedy's schedule is both unique and extensive. It's unique. He's the only pro tem in the state of Georgia, and it's extensive because he's got to be at these meetings all day, all the time. He doesn't need to be here for a deposition. Then I've met the burden of saying that he's an officer. On the opposite side, I could argue, well, he is unique because he's the only pro tem in the state of Georgia, but he's not unique in the world. There's a pro tem in South Carolina, Florida, et cetera. So I think to some degree we are arguing semantics here, but I think it does make it a two-part test to determine whether or not you're an officer. it's going to come down to just practical good sense by a judge to determine whether or not he's an officer or not. I think the point I'm trying to make is we want to make it as narrowly tailored as possible. We don't want to say that, like I said, someone that's operating a very small business is protected by this. I mean, by its namesake, the way I understand the doctrine, the Apex doctrine, is only supposed to protect from deposition those folks that are at the top of these large organizations. Because on one hand, you're talking about trying to get the information. On the other hand, the proponents of the bill would say, well, there's no need to this is just a tactic to encourage settlement, right? To say, we're gonna depot your CEO if you don't settle. So this is the protection that we're offering, to say that if it's a high-ranking CEO and you don't have that unique knowledge, then.
All right, so you don't protect all CEOs. They would have to be a CEO that, in your version, had a unique and extensive scheduling demands or responsibilities. Why wouldn't we just assume that every CEO has a pretty extensive schedule and has demands and responsibilities commensurate with their office?
Well,
I mean, we could just say officer means a high-ranking officer of an organization. But you want it to be more limited than just the CEOs. They got to not only be a CEO, but they got to come in and prove to the judge to get this protection that they have extensive scheduling demands and that they are unique in some manner. Unique is like, a unicorn, one and only type thing.
I agree.
All right.
So that's a policy objective, and again, I will defer to the wisdom of the committee here. I think that this is, again, the Apex doctrine, and as it's applied at the federal level, it is for those high-ranking officials, those officials that are at the top that have these extensive and unique scheduling demands. And the point you're making is a good point. Why don't we want every CEO to be protected by this? I would submit to you that I'm a CEO of a small LLC. It's just me and my wife. So should I be protected by this because I have a unique and extensive scheduling? If we don't define it like that, we just say the CEO.
But you also, in a different section, you have to have unique knowledge about the subject matter in the lawsuit.
That's correct.
So why shouldn't we protect every CEO that doesn't have any particular knowledge about the events in the lawsuit, whether or not their schedule, even may have a schedule? Who cares? They may be fishing in the Bahamas or something. But they still don't have the knowledge, and y'all have added on this additional qualification before they get protected from harassment by depositions, which is what created the problem. They were saying, look, I don't know anything about this. This is not in my knowledge base. And now I have to say, not only do I know nothing about it, but I've got a very unique and extensive schedule, and I don't have time for you. Even though I don't have knowledge, I don't have time.
Well, again, you're making good points, Chairman, but I would say that this was brought to us by the business community. And and the reason it's brought to us is because the state of Georgia currently, if we don't pass this, there's no protection. If it's relevant, I can take the depot of anybody, anywhere, period. And if that's what the policy objective is, then that's what we'll do. But we're trying to make it safer for businesses. This is the number one piece of legislation that GM wants to pass under the Gold Dome, General Motors, because of what you're saying. Their CEO was called in for a deposition, and she claims that she has no unique knowledge, but she gave some knowledge at a congressional hearing, and because we are where we are in our policy, she was allowed to be depoted. And in that case, in the Buchanan, if this were enacted just like it is right here, they would be protected, or she would have been protected.
Well, what GM and these other executives brought to the Senate was Senate Bill 200, which mimicked Florida's law, which after the executive declared by an affidavit that he did not have special unique knowledge about the matters in dispute in the lawsuit. Then the burden shifted to the person seeking the deposition to show that, not rebut that his denial of knowledge, and also show that they'd exhausted all other means of discovery and there weren't other ways to find the same information. So what they wanted was not the House version. That was a compromise that you guys worked out somehow to get that through the House.
Well,
we're going to hear from them. We'll hear from them. I don't mean to be
Well, no,
harassing you, but it's almost like we're making a mountain out of a molehill here, and it gets my antenna up why it's being fought so hard, unless that's a loophole that negates the whole meaning of the bill somehow. I mean,
quite honestly, I think that, I refereed the meeting. So I was there when the person you mentioned earlier was in the meeting with the opposition, and we went through the bill and we called out each section that was at issue or needed to be worked on. And quite frankly, Mr. Chairman, the unique and complex was something that was questioned or asked for after we had that meeting.
okay. Well, you got to love the, bicameral legislature. It gives us time to air all these out. Madam Leader, I'll recognize you for a question.
I do have a question, Mr. Chairman. I just want to know if the CEOs are above the law. It's
No.
The way you're talking about them as if they're exempt.
No, I don't think they're above the law, but I do think that they should be afforded the opportunity. Like, for instance, if the CEO of GM is called in for a deposition to testify to whether or not there was design flaws with the cab of a truck. Why would you call the CEO in when you could get the engineer or you could get the regional person to do that? That goes to the point that Chairman Cowles is talking about. That's just plausibly you can make the argument that's just a tactic for settlement. I'm just trying to be harassing so that you'll settle. I don't believe the CEOs are above the law.
All right, thank you. If you'll stand by, we've got a couple of people signed up to speak. Alan Richardson, Georgia Pacific.
Thank you, Mr. Chairman. Alan Richardson on behalf of Georgia Pacific. We are supportive of y'all addressing this matter. Our company, which has 8,000 employees here in Georgia, 30,000 across the U.S., going to Madam Leader's statement, the CEOs do get harassed with legislation, trying to bring them in on issues that they do not have unique knowledge about. For example, what we're talking about here today, should someone be able to subpoena and deposition Governor Kemp, who doesn't know what's going on here, but he is the CEO of the state of Georgia. So we appreciate y'all addressing this. I mean, Georgia's been a great place to do business, but we've had some judicial hellhole issues here, and this is a step in the right direction to get us back on the right path, and we're supportive of your efforts. Any questions?
Anybody got questions, Mr. Richardson? No, thank you.
Thank you, Mr. Chairman.
Robert Highsmith, Georgians for Lawsuit Reform.
Thank you, Mr. Chairman. Robert Highsmith with Holland and Knight. We actually argued the Buchanan case before the Georgia Court of Appeals that the representatives were speaking about, and then Justice Blackwell argued it before the Supreme Court.
Give us just a little overview of that case, because that's what got this entire, nobody in this building had ever heard of the Apex Doctrine until that case. Let's hear
Sure,
about it.
and I'm
Including
sorry,
most
Mr.
of
Chairman,
the
I was trying
lawyers,
to hit it quick because
okay.
I know the
Okay.
hour, but sure, the CEO of General Motors, Mary Barra, was sought to be deposed in a case where there had been a fatality involving a General Motors vehicle. And they sought to impose or to use what's called the Apex Doctrine. It's a doctrine that has not existed in Georgia law, but exists in the laws of several other states that says if you're at the apex of an organization, you have to, before you can be deposed, you have to establish several things. And it's the things that this bill seeks to establish, seeks to codify in Georgia. Do you have unique knowledge as a CEO? Madam Leader, it's not that they can't be deposed, it's that, let's have a reason to depose them as opposed to, the engineer, as the representative stated. And and they tried and failed to have the Apex Doctrine be applied here in Georgia. The Georgia courts, both the court of the trial court and the Court of Appeals, and then the Supreme Court in the Buchanan decision last summer said, we're not going to adopt the Apex Doctrine. The Apex Doctrine is, again, what this bill would seek to codify. Do you have unique knowledge? Are you an officer in a high-ranking organization? And what the Supreme Court said is we're not going to adopt the Apex Doctrine because it's not in statute. The General Assembly in the Georgia Civil Practice Act, which this bill seeks to amend with the addition of a new section 26.1, the General Assembly has not spoken on this issue and has not passed into the Civil Practice Act these factors. And so we, the Georgia Supreme Court, are not going to sort of legislate these factors into the statute, Mr. Chairman. They said they're good. What Georgia law does currently say is that you have to have, you can get a protective order for good cause shown. Well, what does good cause shown mean? And the Supreme Court sent this case, the GM case, the Buchanan case, back to the trial court and the Supreme Court said, you know what? We think these are good factors to look at. We think they're important factors to look at. We're just not going to say that they bind the trial court because the General Assembly has not spoken on the issue, Mr. Chairman. These two words that are the focus of today's debate between the House version and the Senate substitute are not words that have appeared traditionally in other states that have adopted the Apex Doctrine. I'm unaware of any state that says you have to have a unique schedule in order to avail yourself as a CEO of the Apex Doctrine. The questions, Mr. Chairman, that you were asking were very appropriate. What is a unique schedule? I would have a very difficult time as a lawyer saying that Ms. Bera's schedule as CEO of General Motors is unique from that of the CEO of Ford or of Kia or everybody else. I mean, it's you know, their schedules probably look a lot alike in terms of what the duties of the CEO of a major international car manufacturer. Similarly, the word, we didn't talk about it as much, the word complex, but 2 lines later in the House version, in line 45, you have to be the CEO of a large and complex organization. And what those 2 words would do, Mr. Chairman, would be to get, what those 2 words would do would be to give folks the opportunity, exactly as you said, to say, well, you know, I'm making this up, Mr. Chairman, but you know, Hobby Lobby is a large organization, but it's not complex. It's a store that, you know, sells hobby supplies. Again, I want to be very clear. I'm just making that up as a potential example of an argument that somebody might make. Again, Ms. Bera's schedule is not unique. Look at the Ford's schedule. He too had investor relations at 9 a.m. and a board meeting at 10 a.m. and then he flew to Japan. You know that those are the arguments that a plaintiff's lawyer would make to say that this person's schedule is not unique and therefore they should not be able to take advantage of the provisions of House Bill 530. This organization might be large, but it's not complex. Just one more word that someone seeking to avoid application of what might become Georgia's Apex Doctrine, and that's why the Senate version takes them out. And again, my role here, Mr. Chairman, is simply to point out to the committee that in other states that have sought to impose some version of the Apex Doctrine by court decision or by legislation, those 2 additional hurdles, Mr. Chairman, as you pointed them out to be, are not typically part of those states' analysis that have adopted this, and they would potentially raise additional hurdles to high-ranking executives that sought to avail themselves of legislation that the General Assembly would pass.
And this version that passed the House, as well as the substitute that we're considering today, both put the burden of proof on the president of the corporation, the high-ranking officials that's seeking protection.
As does existing law. You're absolutely right, Mr. Chairman, and that's also true of anybody seeking a protective order has to make the showing. And what this bill would do is specify the things that someone seeking to take advantage of what I'm shorthand, the Apex Doctrine, what they would have to demonstrate. But yes, the burden is on, in the case of the CEO of GM, it's on her, you know, and not on the plaintiff or other person seeking to take the deposition of a high-ranking officer.
Whereas the original Senate version of the Apex Doctrine in SB 200, once the corporate official said they didn't have unique knowledge, et cetera, then the burden shifted to the party seeking the deposition to persuade the judge that, yes, they did, or there's no other way to get this information. We've exhausted other means.
Yeah, that's my understanding, Mr. Chairman. I boned up on 530 more than I did 200
All right,
for this
fair enough.
afternoon, but that is my
Any
understanding.
questions from committee members? Mr. Highsmith. All right, that's all we had signed up to speak today. Thank you, all of you.
Thank you, Mr. Chairman.
If you'll stand by, Mr. Burchett, in case there's any other questions for you. Yes, sir. Senator Brass.
I
you're
got a
recognized.
question, I guess, for you, Mr. Chairman. So what exactly did we change in the substitute?
Online, all right, you'll see in your folders LC 44-2300, which was the original version. The substitute is LC 44-237-8S. On line 43, we took out the word unique. So all we did, take out one word, and on lines 44 and 45, we took out complex. So the
That's it?
organization- That's it. That's what we're sitting there arguing for 30 minutes over.
Yeah, pretty bad, pretty bad.
Now, I will say, should be in our folders, the Metro Atlanta Chamber, the Georgia Chamber, and the lawsuit, Georgians for Lawsuit Reform have all endorsed the Senate version here. Any further discussion from the committee or additional questions for the House Whip? All right, what's the pleasure of the committee? Got a motion to pass by committee substitute, LC 44-237-8S, and a second by the President Pro Tem. Any other proposed amendments? All right, all in favor, raise your hand. All opposed. Did you get the count on that, Cindy? Any, you opposed, Madam Leader? Okay. Got it? All right, let's do it again. Pay attention. All raise your hand if you're in favor. Any opposed? That's correct. All right, we got 2 noes. All right, that passes. We'll send it on to Rules Committee.
Thank you, Mr. Chairman. Thank you, committee members. Appreciate
Thank you.
the time.
And I'm happy to continue talking with you offline, Mr.
Oh, yeah.
Whip.
Very,
Okay.
appreciate you.
All right. Okay, the other bill on our committee is we'd like to finish up our hearing on the hemp bill. I had extensive testimony the other day, Representative Perkle, as you heard. I got quite a few more signed up today that want to be heard on that issue. Some are repeats that were already heard the other day. I'll save you till the end if we have time. I want to tell the committee where we're headed the remainder of this session. We have a meeting tomorrow morning at 10 a.m., and we're going to be discussing the cannabis bill. I think that's 198. That deals with additional licenses, et cetera. We have this room from 10 until 12, and I want to focus that meeting on that bill. We also have a meeting Thursday morning here at 10 a.m., which will give us time to complete any action. My hope is, and we are going to finish any further testimony on the hemp bill today. If we have changes to make based on the aggregate testimony, we will have a committee sub. Representative Perkle, I will naturally talk with you before we make significant changes. I don't really know what the will of the committee is going to be, but if it's ready by tomorrow, we may have a vote on that tomorrow. If not, be prepared to vote on that on Thursday morning. Cannabis is pretty complex subject matter, licensing scheme, et cetera. I want to give that a thorough hearing in deference to Chairman Powell. We'll spend tomorrow morning on that as long as it takes a couple of hours on that. It's a committee day. And then if changes are necessary, we'll be able to make them tomorrow afternoon, and then we'll also be able to vote that bill on Thursday morning. So that's the bills. There was also the refrigerant bill that will probably be back on. The sponsor of that bill wants a vote. I don't know what the will of the committee is, but we'll have time to consider that as well. So that's where we're headed. Representative Perkle, just since you look so Frisky over there, is there anything else you wanted to add before we start taking testimony, if you have any additional thoughts, because you might want to respond to some of that testimony we had the other day?
Yes, sir.
All right, so I'm going to give you, the podium would be probably easiest.
Okay.
And if you just say any additional comments you have, we may have some questions, then I'm going to start calling some additional witnesses.
That is very kind of you, Mr. Chairman, and thank you for the committee. I walked into regulated industries and wound up in judiciary. I had never done that before. But one of the testimonies that we heard, and in the last hearing we had, there was someone that testified that it looks like we pulled the numbers out of thin air for what we have for the tolerance for our full panel. And so I wanted to just kind of justify some of the numbers, since that was taken, I don't know, it seemed kind of harsh to me. And it was not taken from thin air. It was, unless the Colorado area is fairly thin. Most of the changes that we have, that as it relates to the residual solvents, which is the bad stuff that we want to make sure that we're protected from. Benzene, we have an amount less than 1 parts per million that is allowed in Georgia code. Colorado has about twice that. Benzene is something we want to stay away from. We know that it causes leukemia, so we don't want that in the stuff for Georgia consumers. Secondly, hexane, our level is significantly less than in, say, in Colorado, which is where I pulled this other data from. So hexane allows about 30 times what is in this bill that we allow. Hexane, for those of you that missed the chemistry class, is used in cleaning products. So while I love Lysol in certain areas, not in my body, in contact with water, it releases a flammable gas that may ignite spontaneously. You don't even pour this stuff down a drain. And so we have less than 10 parts per million. In other states, particularly Colorado, it's in that 290 range, parts per million. And so ours absolutely is a tighter standard for the things that can cause us problems. Most of the others are in the same alignment as other states have with ethanol, and the xylene also. You don't want that. It's less than 1 part per million. So that is just some of the changes I want, not changes, but the response I wanted to make through the testimony we had the other day. When I made my statement that this language is designed to be tightly drawn, I was actually serious about that. It was not flippantly made. I want firm guardrails on this industry, and I feel like this language that we have in this bill does that. Thank you, Mr. Chairman.
Hang on one second.
Yes, sir.
I think one of the motivations for the bill is that the federal law hemp bill was passed in 2018, restricted or prohibited the Delta-9 components of some of these CBD oils that had psychoactive effects potentially.
Yes, sir.
But then the industry sort of found a way around that by using Delta-8 instead, which not as strong, I guess, as Delta-9, but could still, in the certain concentrations, have some psychoactive effects, get people high, whatever. Is that your understanding?
Yes, sir. Well, the intention of the bill, there again, guardrails. I did not focus on the deltas because Delta-8, Delta-10, Delta-12, I did not focus on the deltas. What I looked at is these things that we know to be harmful solvents that are used to derive Delta-8. So, for instance, as a farmer, if I took some Thimet that I use on my cotton to put in furrow insecticide, and I spilled it on the floor here, and I took honey, and I dribbled honey over the top of it, and I got down on all fours and I licked up that honey. The honey's not what's going to make me sick. It's the carrier to the honey that's going to make me sick. I wanted to make sure that our emphasis there again, to me, this is a consumer safety issue, and it is about providing consumer protections that we don't have now, which is the whole impetus for me for this bill.
So you don't really care how much THC's in it as long as it
No,
doesn't
sir,
have
I
insecticide?
absolutely do. In the parts of, it's on like line 35, 36, in that area, I specifically address total THC is the sum of all these others that should not be over 0.3% on dry matter. It's the sum of, so I did, that is very important to me. Yes, sir.
Right. And if any other people testifying have more knowledge, help me out, and the committee out. I'm told there's already about 14 states that have attempted to close this loophole by banning Delta 8 altogether, and I'm not sure. I was not a good chemistry student, and so I'm not real sure that I comprehend all the different isomers and esters, et cetera. So y'all help me.
So,
along.
Mr. Chairman, I have not been a great friend to some of my lawyer friends, but I did pull up the National Law Review of last week, and it quotes, despite many unknowns and uncertainties about Delta 8, it remains federally legal, yet unregulated. So, so while I'm not trying to add loopholes, I'm trying to make our definition consistent with federal language and still protect the citizens of the state. That is my intention.
You got that letter? Let me have it. All right, any questions? I think Senator Rhett had a question. Go right ahead.
Thank you, Mr. Chairman. I didn't do too well in chemistry either. Did a lot better in biology. But the last time you smoked some, could you tell the difference between Delta 8 and Delta 9?
So I must say, Senator, thank you for the question. I have never partaken. I will stand by my last statement that I am like the church lady on Saturday Night Live, and I would have no knowledge. Thank you.
All right, Senator Brass, I recognize you, then Senator Dolezal.
Thank you, Mr. Chairman. So, thank you, Representative Perkle, for bringing this. We heard some testimony the other day, and I just kind of wanted to get your thoughts on, and let's go to start with on lines 265 through 267, where we're capping the milligrams on a per dose basis and also on a per individual package basis. And I kind of brought this up the other day, is if we're limiting that, then you're kind of ruling out a lot of your topical type of creams, and I just want to make sure that's not your intent.
That is not my intent, Senator.
Okay. So
and I
would
don't mean
you
to cut
be-
you off, but
No,
I
no.
do have testimony today that will clear that up about the topical creams and the THC that is in these.
Okay, well, and I guess a follow-up too, Mr. Chairman, but if
Go ahead.
if we're limiting the percent of THC, which,
Yes, sir.
I mean, federal law limits that anyway, what's the point in having a milligram per individual dose? Number one question. Number two, my understanding is on vape products, on the cartridges, because I had some follow-up conversations after what we learned the other day. One thing I learned was on vape cartridges that you can't find a product under 1 gram or 1,000 milligrams. So if you're limiting it to 500 milligrams, then essentially we're getting rid of all vaping as well on that. And I just want you to understand that, and that may be your intent. I don't know. I'm just asking.
So, as the person that ran a vape shop testified, this bill would provide about 65% of the products that they are currently using to not be legal.
Mm-hmm.
I would concur with that.
Okay. I mean, are you dead set on those numbers? Or are you amenable to amendments to where we're not going to outlaw them? We're still going to keep them safe,
Yep.
but we're not going to outlaw them.
So there again, I want firm guardrails in place. I feel like it does it with this. I'm currently at the mercy of my friends here. But before you make that decision, I really would like to hear from a phone a friend that has agreed to testify today.
Who's your phone a friend on that, so I can make sure to call him? 'Cause we're
Mr.
gonna run
Wingate
out.
will be talking about that
He's on the
specifically.
list.
Yes,
All
sir.
right, Senator Dolezal, you're recognized for a question there.
Thank you, Mr. Chairman. Thank you, Chairman Perkel. Have you had an opportunity to review the letter from the Georgia Sheriff's Association?
Not only did I review it, I talked with the president of the Sheriff's Association as well as my sheriff, who is on that list.
Would you mind, maybe for the benefit of, well, me and the others who don't understand everything that's in here, could you highlight their high-level concerns and maybe your response to those concerns?
For committee members, you'll see in your folder a letter from the Georgia Sheriff's Association objecting to some aspects of the bill, and also one from the U.S. Department of Justice Drug Enforcement Administration that's reads to me like they're saying that the Delta 8 is a controlled substance. Go ahead.
So part of their concern regards, if you look on the second paragraph, they were concerned with the THC levels, 40% or more THC. Some sheriff's offices noticed Delta and convenience stores boasting THC content exceeding 90%, which is currently illegal under our current law. So the conversation that I had with the Sheriff's Association, and there again, I had a quite comprehensive conversation with them, and I do hope they're here to address their concerns, because it puts me at a little disadvantage to know exactly, since you've got their concerns here. I felt like in our conversation I addressed all the concerns they had, but they were concerned about the health and safety of the citizens, as am I, and I'm not sure how fully they had absorbed this bill before this was written.
If I could have a follow-up, Mr. Chairman.
Go right ahead.
The second sentence of their letter, if you could comment on that. Specifically, our sheriff strongly opposes language concerning Delta 8, Delta 10, and hemp edibles. Do you know, did they tell you what they oppose, and maybe share your thoughts around that as well?
There again, I could not comment on what they meant by that, but I can say that they're concerned, as I am regarding anything that our consumers are taking that can harm them, which is part of the reason why these guardrails are so stringent.
But you don't, and I'm just genuinely trying to find this in the bill. You don't know what language it is that they're referencing as it relates to 8 and 10?
No, sir.
Okay.
No, sir.
Senator Lucas, you're recognized for a question.
In the bill, you have the, right above Section 7, the 25 to 500 milligrams.
Yes, sir.
Which testimony said that people will end up over it because some of them are taking more than that now, and they will have to buy more packages of 25 in order to get it. Where are we with that? If they're saying that some of these folks might need 95 milligrams, not 25.
So there again, Senator, when there will be testimony today that will absolutely address just above Section 7 on lines 265 to 267. Yes, sir.
All right, let's hear some testimony. Thank you, if you'll
Thank
stand
you.
by. Greg Raduca, I promised you last meeting, since you were the next on the list, that I'd call you first today. If you'd take the microphone, please, there, and let's hear what you got to say.
Thank you, Senator. For the sake of time, I was going to let Dr. Lopez go first. He cannot be here tomorrow morning.
That'd be fine.
Thank you.
Doctor, you'll need to identify yourself, tell us who you are, where you work, and what your views on this bill are.
Good afternoon, everyone. And again, thank you for allowing me to speak today on 458S. My name is Gaylord Lopez. I am the Executive Director of the Georgia Poison Center. It's a 24-hour 911 service for poisoning emergencies. It is housed at Grady. I have been director since 1988. I'm a doctor of pharmacy by education. I'm a board-certified toxicologist by postgraduate training. And as I said, I've been in place for the last 3 decades. I want to first start off by telling you that I did have an opportunity to view the hearing last week. And while I'm not a business owner, I'm not a farmer, I'm not a producer, I'm not even a user, I can appreciate the passion that these folks had in testifying about why the bill should move forward. However, my passion for keeping Georgians healthy and safe of poisoning hazards is just as strong. The information I'm sharing today comes from my experience as a clinician and from a chemist, to help you out, Chairman, and from data collected by the Poison Center here in Georgia and centers across the United States. Nationally, the trends for accidental and intentional poisoning from consuming edibles containing THC is rising. Nationally, for example, in 2019, there were 2,500 cases reported. Fast forward to 2021, 6,760. In Georgia alone, the cases that we've handled have tripled. We had a mere 77 in 2020. In 2022, we had 277. Pediatric cases in that same time have more than tripled as well for us in Georgia. Children less than 12 years of age make up 38% of the calls we get. Patients who are considered pediatrics, those up to 18, make up just over 98% of the calls that we get. Hemp-derived products containing Delta-8 have been all the rage the last few years. And in fact, in May of 2022, the FDA issued a warning, you're probably familiar with this, issued a warning about the dangers of CBD and Delta-8. That was not clearly stated at the last hearing, but in that statement, they were telling us that Delta-8 used as a food additive in any human or animal products was not considered safe. And so, if you look at our data, over the last few years, we've had nearly 500 cases reported to the Poison Center, and shockingly, 44% of those cases were Delta-8 related. To illustrate the dangers of Delta-8, I know there was testimony about how people have never heard of a problem with Delta-8 and talking about the purported benefits of Delta-8. I'm gonna share just quickly with you a case that we had just a couple months ago where a physician from Kennestone was calling us about a 2-year-old who came in incredibly drowsy, somnolent, and lethargic. All they were purported to have done is take one Delta-8 gummy. The patient was in the hospital in the ED for 4 hours. The parent then brought in the package, and sure enough, it was labeled Delta-8. That patient, because they were not able to be admitted to Kennestone, they had to be transferred to Choa Scottish Rite, where they went into the pediatric intensive care unit for the next 24 hours for observation. In Georgia,
So what is it, the THC in the gummies that's causing the reactions, or the
It's the Delta-
insecticides or whatever?
no, it's the Delta-8. Delta-8, Delta-10, the isomers of THC are the ones that are causing the problem, not the hexane, not the benzene. It's the Delta-8. If you're familiar with isomers,
No, educate us.
I will
Their
educate you.
combinations is all I know.
The simple definition is this. It's the same chemical structure, but different arrangement of the atoms. For example, if I told you my name was Dale, I use the word D-A, I use the letters D-A-L-E. But if someone's using those same letters and their name is Lad, L-A-D-E, that's an isomer. So it's the same chemical structure, the same chemicals used, but differently arranged.
So what's delta stand for? What's that mean, delta?
So delta is the place where the double bond, if you remember from chemistry, single bonds and double bonds, it's the position of the double bond. And so for delta 8, it's between position 8 and 9, and for delta 9, it's between position 9 and 10. So that's just a fancy term for, it's just structured just a little differently, but using the same atoms.
This letter from Department of Justice, if you all get frisky, turn the page, has those actual drawings of the molecules, et cetera. Okay, didn't
So-
mean to get you off track.
Okay,
We
so-
keep talking about delta,
Okay.
and I want to know what it was.
Okay, so as I said, this kid was later discharged from the PICU, from the PICU. Today, and as we move forward, we have an opportunity here in Georgia to minimize poisoning to our most vulnerable patient population, and that's the young. We really do need to close this loop of the isomers, because it's the isomers that are being shown to be psychoactive. And the thing is, you were asking about dosage, Chairman, and people were asking about, what's the proper dose, or there's 25 milligrams in a gummy, there are 500 in a bag. Here's the problem with dosing. That's all hocus pocus. That's all Dr. Google talking. Find me a clinical study, double-blinded, crossover study involving the use of Delta 8, the use of Delta 10. You're not going to find it. Why? Because it's not being tested in humans. And so when people are saying, I need a dose of 800, and I might need to buy 2 packets instead of 1, where are they getting that information from? Dr. Google's one of our biggest adversaries out there in the poison world. Everyone wants to play doctor. And I'm not doubting that for some patients there may be some relief, but find me a clinical study that shows that. So this study, the talk about limiting to 25 milligrams, limiting to 500 in a packet, to me, the issue is Delta 8 has shown to be a psychoactive compound, similar to Delta 9, which is marijuana, which is not legal in our state. I say we have an opportunity to close that loophole, and if we do that, we will minimize poisonings in our population.
All right, thank you. We've got just a couple of questions from committee members, then we'll let some other people speak. Mr. Vice Chairman, Senator Summers.
Thank you, Mr. Chairman. Okay, you kind of got me a little confused here, and I understand where you're going with this, but I'm just curious about a couple things. And I've been trying to take notes here and go through the bill. Synthetic Delta 8 or Delta O, which is sometimes referred to as Delta 10, it's not in CB under this bill. And we'll have lab tests under this bill. We'll have QR codes on these products to let people know what they're taking or whatever. And you're trying to sit there, I think what you're trying to tell us is, we want to get rid of Delta 8. You want to stop Delta 8. That cat's out of the bag. I mean, these kids can buy it over the internet. They can buy it anywhere. And if they can convert Delta 8 to Delta 10, you can take Delta 10 and convert it to Delta 6. I mean, if you know your biology. I mean, you know what I'm saying? You know your stuff. You make these things happen. So what I'm getting at is I appreciate where you're coming from, but alcohol poisoning kills every day too, or causes people.
All right, you got a question, ask it.
Thank you, Mr. Chairman. I'm trying to.
All right, and enjoying your speech, but you got a question, ask it. We got all these people out here who want to be heard.
Make me understand why you want to take Delta 8 and Delta 10 out in a short way of time when we're going to have all these controls on there, and it's proven so far from people that's taking it that they do get benefit out of it.
Delta 8 and Delta 10 and the other 98 isomers that are out there that can be derived have to be individually studied before we say it's okay to use. The problem is we are currently seeing problems with Delta 8. So I'm saying if you're talking about what we need to do with this bill, we need to include all isomers. That's the problem, not just 8 and 10, but the other ones that are going to be developed, soon that may very well have just as potent effect as Delta 9. We're seeing clinically that Delta 8 is causing kids, 63% of kids who got into Delta 8 over the last 2 years here in Georgia have had to go to the emergency room. 68%.
Follow-up question. Follow-up, Mr. Chairman. That might be because we don't have any, I'm sorry, sir.
Go ahead.
That might be because we don't have any controls on the bill, and that's what we're fixing to try to do, is put some controls there with a QR code that tells people where it comes from, and when they get to the emergency room, if that's the case, that bottle can be scanned and know where it came from.
Is that a question or is that a comment?
I'm sorry.
Okay, we're going to have discussion at the end if the bill gets on the table. All right, any other questions? Are you through?
I am.
Thank you. We appreciate you being here.
Thank you.
All right, Mr. Will Wingate. And just sort of give y'all, get queued up out there if you're ready to.
Thank you, Mr. Chairman. My name is Will Wingate. I'm a fourth-generation native of Irwin County. I'm a reformed lobbyist, so it's good to see some of my friends here. I am the co-founder and CEO of Second Century Ag in Ocilla. We are the only operational hemp processor in Georgia. We were licensed in 2020. We helped Chairman Tom McCall write the original legislation when it happened. Licensed in 2021, 2022, and we were licensed for 2023. So we've paid over $125,000 in fees to the state of Georgia to be a processor. I come to thank Chairman Perkle for his work. He has been very studious in learning about this industry. I want to thank my neighbor Tyler Harper, our new Ag Commissioner, for showing an interest in the hemp industry and for willing to learn about what we're doing. Mr. Chairman, we're the largest farmer in the state of Georgia. We're the largest processor in the state of Georgia. We manufacture products. We have control from the seed to the finished product. We know exactly what is in this product. We know where it was grown. We know what steps were taken to deal with fire ants and spotted wilt virus and mold and everything involved. You cannot have an industry if you do not have guardrails. This legislation, for the first time, puts some standards and guardrails on the hemp industry in Georgia, and Chairman Perkle, we are thankful for that. Now, there are a lot of different ideas about what should be in and what should be not included in this legislation. I don't think anybody's talked about the farmer piece, Mr. Chairman, lowering of the fees.
They did the other day, but you can make your comments on that as well.
Yes, sir. We want to encourage competition. We want more processors in the state. It's not practical for a grower in Dahlonega, Georgia, to have to drive all the way down to Irwin County to process their material. If we can lower the processing fees and the bonding and the cost, then we're going to grow an industry. So even though we're the only ones left, we want competition. We encourage this industry as itself to grow. We are fully in support of the QR code, the full panel COA on the finished product. It is expensive to do, but we do it throughout every step. We do it in the field. We do it when we create distillate. We do it when we create finished products. We think it's a consumer protection provision that needs to be in there. And if we do not pass this legislation, there's not going to be any standard at all. It is the Wild West. You can go buy a gummy packet in a gas station and you have no idea what's in it. You don't know if there's Delta 8, Delta 10, THCO, because there's really no way to track it. This legislation will enable the Department of Agriculture to be able to go in and create a way and a method where you can test this product from the field like they're doing now to the finished product. And if you're going to grow a standard and a high standard and a high-quality product in this country, it needs to be done in Georgia. There's no doubt our farmers can grow a high-yield, high-quality product better than anybody in the country. We've got water that Colorado doesn't have. We've got tobacco farmers with infrastructure in place that they can seamlessly transition from tobacco to hemp. Everything is there, Mr. Chairman. We can grow this industry and we can be the leader.
We had some testimony the other day. Did you actually draft the bill, or your company have it drafted?
No, sir. Chairman Perkle drafted the legislation.
Okay. What about all the licensing? Why would you want that another layer of government regulation to start licensing convenience stores and gas stations before they sell a product that is a legal product and, according to many in the room, harmless?
The only way, and I don't want to speak on behalf of Commissioner Harper, but right now the guy that grooms pets in Lax, Georgia, where I'm from, sells CBD products for us. There's no record of who actually is selling this product. There's no way.
We don't have a record who sells potato chips or hot dogs either. Why?
Because you have to have a record to know who actually has products on the shelf, so therefore they can be tested and appropriately monitored to make sure that the QR code and the product they're selling meets those standards. The fee that's y'all's decision. If you have a registry of who is actually selling this product, then the Department of Agriculture, like they do in grocery stores and gas stations, knows who do they need to go check to make sure that the inspection is being done appropriately and the products that are being sold meet the truth in labeling tests that we're trying to set forth today. The fee is immaterial, but you have to have some record of who's actually selling this stuff in order to find out, is this truly the product, is this product what it really says it is, or if there's any labeling on it whatsoever. Now, as far as the 25 milligram and the 500 milligram, Chairman Brass, you brought up, we make products that have 1,000 milligrams of CBD. They have 1,500. I don't think that cap has anything to do with CBD or CBN or CBG or any of their minor cannabinoids. I believe that was just the cap for the amount of Delta 8 or Delta 10 or whatever the isomer of THC is. That's where that cap came in.
Chairman Brass, you're recognized for the question.
Thank you, Mr. Chairman. Well, I'm sitting here eating a pack of gummies, and I ate a pack, and I wasn't satisfied, and so I just opened up a second pack and started eating it. And so I guess my concern with if we're going to cap these doses, if I want more, I'm going to get more, and I'm just going to keep eating more and more and more until I'm satisfied. And I don't know what we're chasing with Delta 8 and Delta 9 and all this other stuff, but I do know that if I buy a 12-pack of beer and I get to number 6 and I'm not satisfied, I'm going to keep going. And so my concern is if we're capping these things, why would they not? I mean, they're just going to keep eating them anyway. And so that's kind of my concern with the caps, and then that's one concern on the individual dose. But my bigger concern on that package dose is that we're outlawing, I mean, we heard testimony, I think she said 80-something% of her products were going to be obsolete. That's from a business standpoint. I mean, you're a businessman. I mean, that's, to me, it's not fair to them as business owners to put that on them. And that's the only part I'm getting really hung up on.
Right, and I understand. There are 500 milligram vape carts out there. We make them. The issue that you're dealing with a lot of the vapes that are out there, we've been asked as manufacturers to make them as cheaply as possible, put vitamin E in them, put propylene glycol in them, and we absolutely said this is ridiculous. No, we're not doing this. The debate between the Senate as to what the milligram cap of 25 milligram or 50 or whatever and 500 versus 1,000, that's for y'all to decide. And that may be a longer debate. My my point to get across to you guys is we need some guardrails on this industry. We need some legislation to move forward to allow this industry to prosper. I've got farmers lined up now ready to grow 500 acres if they feel like there's going to be a market for this, who've been screwed over by, pardon my French, by tobacco companies in the past who want to get into a new industry. We can be the gold standard in Georgia if we allow guardrails on this industry to allow it to grow and to move forward in a very professional manner.
Senator Harbison, you're recognized, then Senator Dolezal.
Thank you, Mr. Chairman. I believe one of the things that we discussed earlier was about quality, right, and control of that quality. And if I'm correct, you are competing with border states. Is that right? Would that be fair, like Florida and Tennessee, up South Carolina perhaps? And it may have a higher dose of whatever the bad stuff is in Delta 8 or whatever the case may be, and you are confined to 0.3%. Is that, am I hearing that correctly? Okay.
Chairman Harbison, yes, we compete with other states. There are no ramifications if you make more than a 25 milligram gummy in other states. Other states do that. That's not really an issue with us. What we want to make sure, though, is that we have the cleanest product on the shelves in Georgia.
Yeah.
And the cleanest product is going to follow the protocols regarding pesticides, heavy metals, residual solvents, everything that is laid out in this legislation. That is a clean product.
Senator Dolezal, you're recognized for a question.
Thank you, Mr. Chairman. Thank you for being here. You said you all own a testing facility?
No, sir.
Okay, so you do not do testing at
No,
all?
everything we do is third-party ISO accredited testing.
Okay. I think when we met, I mentioned to you that I helped start and was on the board for a while of a nutraceutical manufacturing company. We've since sold it. I know that when we were manufacturing our nutraceuticals, workout products, pre-workout powders, post-workout powders, things like Garcinia turmeric, we would test all of our raw materials inbound, if you will, into our facility. And then we would test our finished product to ensure that what we said was on the label was actually what was in the bottle. I'm curious, I understand this industry is different, but assuming this stuff is made in small batches, I'm curious what the value is of a test that says that the product was tested within the last 12 months. Because I can say that if it's similar to what we were doing, that type of labeling would have been useless because the raw material that came in could have been different, the formulation could have been different, we could have messed something up in the manufacturing process. So is this different in some way, or help me understand the value of something that a formula that you approved that was tested 11 months ago, how that relates to what's rolling off the manufacturing line today?
A very good question. So generally you have lot numbers, you have batches. The shelf life of a product similar to a CBD gummy or a CBN gummy or a sleep gummy or whatever is generally 12 months. Every time that you harvest a crop, our crop varies depending on the farmer, depending on the variety. We have to test different varieties, different times it was harvested to get the different levels of cannabinoids, pesticides, herbicides, all of that. So we test the distillate. Now the distillate converted into a finished product is a second test that you have to do. And it varies depending on the batch number and the lot number when you do that. So our distillate may be tested one time from 2020 distillate. Distillate will last forever. It's like honey, as long as it's clean. The finished product, though, you really need to test that annually because your shelf life is annually on the product. That's why we encouraged it to be a 12-month test. Otherwise, you may have, if you have a test that's longer than 12 months, you may have a product that's been on the shelf for 14 or 18 or 25 months, and it may be not a suitable product.
But is it not true that in the course of 12 months, once you get to scale, you will be running batches that have some level of material, whether it's your distillate or the additives that you're doing to make the gummy? I don't know your manufacturing process. I don't know that as well. I guess my question is, why is every batch not tested?
It usually is. We test every batch.
Okay.
Yeah, we have to in order to get to dial the milligrams in right.
Okay. And is that would you say it's industry standard, or would you say
if you're a true manufacturer, yes, it should be industry standard.
Thank you.
Absolutely.
Senator Summers, I recognize you for a question, but not a sermon.
Mr. Wingate, correct me
Mr.
if I'm
Chairman.
wrong, when your first question that came out once before here, if we have testing, okay, if like all food products have numbers on their packaging, correct? You're simply saying if we did that, I'm just trying to ask this question, then you can track where this product comes from. That's what you're trying to get to. And you know you've got the controls in. Is that correct?
Absolutely.
That's what we're trying to get to on that thing. And then if you go, I'm sorry, Mr. Chairman, we'll follow up.
Go ahead and read, see what they sent you there.
This is what I wrote, Mr. Chairman. I'm just trying to follow up something. Tell me what it would do if, tell me what it would do if, to license it. I mean, this is my thoughts here. If you license it through if law enforcement can see these tests, the Commissioner of Agriculture can see these tests. Is that not correct? And that will know where the products are good or bad. Is that?
Anytime you provide transparency and you have a demonstrated ability for a consumer to immediately access that product, yes, you're putting more information that makes it a lot safer for the public.
That's what I'm getting at.
We see this as a consumer safety bill. Growing an industry, making sure that we do things right in Georgia.
All right, thank you, Mr. Wingate. Appreciate your testimony here
Thank you,
today.
Mr. Chairman. I encourage everyone to please support this legislation.
Dr. Robin Fowler, you still with us? I think I had you signed up.
Mr. Chairman, if it's possible for me to still testify.
Yeah, you didn't waive a chance, but you're not, go ahead, Robin.
I'm completely fine.
Drove all the way up here from Glenville, this might be your only chance.
Okay, thank you, Mr. Chairman.
Who you are. Tell this crowd who you are. You're one of the type 1 licensees on medical marijuana.
Yes, sir. My name is Dr. Fowler. I'm one of the Class 1 winners on the medical cannabis license, and I'm really not involved just with this bill. It's more of an observation role that I play. But for the sake of time, I'm an anesthesiologist, and of course, dealing with the cannabinoids, I certainly feel the benefit. The question to me comes in and with the isomers and the psychoactiveness of Delta-8, Delta-10. The gist is that my concern is that there will be regulation so that it keeps things on the up and up. A loophole to get to THC, I don't think does the community good. I certainly just think that the regulations to keep Georgia as setting the standard would be the best route to go.
Can you give me about a 30-second to a minute explanation of Delta-8, Delta-9, THCO, what that stands for, what that means? I'm grasping for an understanding of the chemistry behind this.
The simple way that I could explain it, I believe, will be the central nervous system receptors that are activated, the CB1 type 1 and the CB type 2. Delta-8 is so similar to Delta-9, THC, it actually activates both receptors, which THC or Delta-9 also activates the type 1 receptor. So we see a correlation with Delta-8, specifically with euphoria, red eyes, dry mouth. Now these typically are at higher doses. We'll say, I think of Delta-8 as more like a little brother to THC. So whenever we look at increase in consumption, I think those are where those concerns really are more validated. And I'll just leave it at that.
So if you eat enough of them or whatever, then it does get you high, the euphoria, whatever.
In the recollection that I have from patients, from family members, from the industry, currently we have, I want to say 19 states that have banning or some similarities or some restrictions at least on the processes or the Delta-8 and industry. So I just think it's worth paying attention to.
So what's bad about Delta-9? Why is it a controlled substance and other forms of hemp or not? Do you know?
Delta 9 being THC, it's a controlled substance, of course, by the DEA. As the previous testimony earlier, they only differ by one double bond. So the isomers are so similar that the DEA actually has come out with a letter to North Carolina that had referenced it recognizing Delta 8 as a controlled substance. So
We have that in our folders. Okay.
that's, that's what I use a lot of, I guess I would say, in my research, my credibility, or excuse me, the credible resources that I look for are some of the agencies that, such as the DEA.
So if the DEA is going to deem Delta 8 a controlled substance in North Carolina, the natural conclusion is it would be a controlled substance in all 50 states once they reach that conclusion?
I don't know that that's my place to give testimony. It's, in my mind, the DEA, of course, is the governing body for the last 20 years in my industry as an anesthesiologist, and I use it very much as a governing body with the Cannabis Commission and with our current license.
All right. Any questions for Dr. Fowler? All right, Greg Raduca, you're back up. Thank you, Doc. We're going to need you back here on tomorrow morning since you're in town. We're going to talk about cannabis, okay?
Yes, sir.
There's a bill that's dealing with licenses like yours. They're thinking about taking it away from you, so you better be here. Go ahead, Greg.
Thank you, Mr. Chairman. I'm Dr. Greg Raduca. I'm the founder and member of the Board of Directors of Georgians for Responsible Marijuana Policy. My background has been in substance abuse prevention and treatment for the last 40 years. Established the first chemical dependency program at Ridgeview for adolescents. And so I wanted to follow up on the remarks of both Drs. Lopez and Fowler on Delta 8. And that is to say that Senator Kay Kirkpatrick, who's also a medical doctor, crafted some wonderful language. It's not that complex, it's not that long, that would solve the Delta 8 loophole problem. Not only the Delta 8 loophole, but all Delta isomers. And it was in her Senate Bill 22. Unfortunately, it is not in 458. But her definition, hemp products means a finished product with a concentration of Delta 9, isomers of Delta 9, esters of Delta 9 of not more than the federally defined THC level for hemp. That does it. And you all would be the heroes of thousands of parents around Georgia if you close that Delta 8 loophole. I get more phone calls and emails about the Delta 8 loophole than anything else. 40% THC in Delta 8 form is not illegal because Delta 8's not illegal. It's kind of that simple. There was a loophole in the federal law that allowed hemp-derived Delta 8, which is made from CBD, to be essentially legal. And that is a big loophole that is causing a great deal of suffering for children, for parents, because there is no age limit in the federal law for Delta 8. So kids can buy it legally according to the Farm Bill. So it's a big issue that Senator Kay Kirkpatrick tried to solve. I hope that you will pick back up on Senator Kirkpatrick's solution. It's an easy one, it's an elegant one, and as was mentioned earlier, 14 states have blocked the Delta 8 loophole. So there's a lot of precedent there. To put this in context, I know that hemp is not marijuana legally, but biologically hemp is marijuana. So really what this would be the first recreational marijuana bill to pass in Georgia. We'd be looking at these edibles on shelves of Publix, shelves of Kroger, CVS. The marketing, unless it's restricted, would have marijuana leaves on the marketing. So as you're going down the aisle and you want to explain to your son or grandson what that is when they ask, gee, Dad, gee, Grandpa, what's that marijuana leaf doing in Kroger? We're going to have to explain it to them. And it's not an easy, simple explanation. So I hope you will consider that loophole. There are also a lot of other things I could say. The ventriloquist that did testify, and I do admire her skills with puppetry, she did say, talking about cannabinoids in breast milk is something that might actually be a positive thing. Just to say that the National Institute of Health professional guidelines recommend that cannabis use should be avoided by nursing mothers, and nursing mothers should be informed of possible adverse effects on infant development from exposure to cannabis compounds in breast milk. So I just wanted to say that. And there's a pediatric nurse practitioner who I hope also might get a chance to testify.
What's her name?
Laura Searcy.
Okay. We'll call Ms. Searcy now. We're kind of running out of time, so if you can keep
I
your
will
comments
keep, and I will not go over ground that's already been covered. Mike, I'm Laura Searcy. I'm a pediatric nurse practitioner. I've been doing children's health policy for a long time. I'm a former 3-term member of the Cobb County Board of Education, and my specialty is primary prevention of substance misuse disorders. My concerns about this bill really crystallize in 3 areas, and they are on Section 6, lines 252 to 255. I understand and appreciate the diligence about the labeling about the product, adulteration, and purity, but if you go take a leave and you pick up a bottle of Aleve in the grocery store, there's health warnings. Keep out of the reach of children, normal dosages. When you have in the alcohol industry, there are health warnings on the labels. In the tobacco industry, there are health warnings on the label. And I think there need to be some warnings that clearly states not for the use of children, can be habit forming, because otherwise, and a big problem with our youth is they think, okay, weed, it's natural, then it's safe, and it's not. The other thing, and I want to bring to the committee's attention, is there, as in a lot of things, there's an adult conversation about these products, and then there's a youth conversation about these products. We are struggling right now to try to pass a series of mental health bills. We have a youth substance misuse epidemic and opioid epidemic that's really rising among youth. We have a youth suicide epidemic. We have a behavioral health epidemic. A lot of that is tied to the changes that occur in the brains of young people when they're at their formative stages between the ages of 10 and 21. And those developing brains are extremely sensitive to even small amounts of psychoactive substances. So anything we can do to delay or prevent the use of any psychoactive substance in youth is going to be helpful, because that usage actually hijacks the development of their risk and reward system and makes them more vulnerable to addiction in the future. And addiction as a substance misuse disorder of any substance, not just whatever they might pick up. And I'm not trying to say that every child that picks up a vape is going to end up in drug treatment, but what I will tell you from the treatment statistics, that 9 out of 10 adults who present for substance misuse treatment began to use a psychoactive compound or a drug before the age of 18. So it's just that exquisite sensitivity. So some labeling that would clearly make it clear that this is not acceptable for young people. The other line I wanted to let you know is there's a line in 355 that states that no person shall distribute consumable hemp product samples on public streets, sidewalks, or parks within 500 feet of any school or playground when such facilities are being primarily used by individuals under age of 21. In our alcohol and nicotine regulations in this state, no sampling is allowed, just because, again, when you have sampling on the streets, it's going to be very difficult to keep access from youth from happening. And somebody distributing samples on the street is going to be expected to card everybody that walks up to them. And if I go to a festival on Marietta Square where there's booths and they're sampling some of these products, has somebody got to walk around and count how many kids are there? And if it's primarily being used by kids, they got to stop? It's an enforcement issue. So I think sampling needs to be done in age-restricted facilities only. I would also ask that, and of course, you would grandfather in existing retail outlets, but to restrict the ability of a licensee to operate within the same distance of schools, churches, or playgrounds that has been in our alcohol regulations since Prohibition, and that's 200 yards. Again, when the vape industry first got going, we had some vape shops that were opening up a catty corner to an elementary school and putting their signs in big, bright primary color letters. So, and then my third and final comment would be on enforcement. And if I could direct your attention to line 369 to 378. And as was stated before, there are going to be thousands of retail outlets that are going to be selling that should not be selling without proper IDing to folks under 21. But the only enforcement in this bill says that any compliance checks or enforcement is a responsibility of the Commissioner of Agriculture acting through special agents or enforcement officers, of whom there are few and already stretched. And just out of curiosity, Commissioner, do you know how many special agents there are? I don't. It's a curiosity question. The reason why I say this is we had the same problem when the tobacco laws were the Tobacco 21 was passed in Georgia, because enforcement is restricted to a very small number of revenue agents. And your local police jurisdictions cannot enforce the law. And if you had a shop, and we did in one of the communities that I've worked with, they knew they had a store that was selling to minors on a regular basis, but they had to get a revenue officer to come with them and actually witness that violation for it to have any teeth. And on top of that, there's criminalization misdemeanors for anybody enticing a youth to buy. But line 376 and 378 said any other use of individuals under 21 years to test compliance or any similar provision shall be unlawful, and the persons responsible shall be the subject to the penalties prescribed in this article. If you're going to put guardrails in place, they've got to be enforceable to protect our kids. And I would just ask that you not prohibit, not mandate, but that you would not prohibit local jurisdictions from being able to enforce a bad actor who's selling to kids. Also, I think that the Secretary has two documents. One was a emergency preparedness. It's called a health action alert that the CDC put out to providers to alert them of increasing issues of children being admitted to emergency rooms with problems with Delta 8 products, as well as an FDA document that explains their position. It says Delta 8 has serious healthcare risks. So I also would support any efforts to close that Delta 8 loophole. And I thank you so much for your attention. I've tried to be as concise as possible, and I appreciate you.
Hang on one second. All right, so you are a pediatric nurse practitioner.
Yes, sir.
In your practice, have you seen children with adverse reactions to ingestion of Delta 8 or Delta 9 or 10 or any of these THC products?
My clinical practice has been lately with newborns, so I did primary practice for 19 years, but before the deltas became practical. What I do right now is I work in primary prevention of substance misuse disorder, and I speak nationally and do training and technical assistance with schools, jurisdictions, including some in the state of Georgia and elsewhere.
So do you think Delta 8 should be restricted from sale to people under 21 or banned altogether?
I think it should be restricted under 21, and I would agree that closing that Delta 8 loophole in the current regulations would stop confusion. And again, if I can draw an analogy.
Well, I was thinking that closing the loophole is a ban. So if you want to close the loophole, you don't want them to be allowed to sell it anymore.
My concern is reducing access to kids, and I would leave, what the decision on a total Delta 8 ban or not, but most of your pediatric professionals would prefer it not be on the market, or if it is, it was labeled and severely restricted against youth being able to access it.
Okay, thank you for being with us today. Okay, I've just about lost my quorum here. I had a couple of people that had signed up the other day and are back again today, and I'm gonna let them speak. I'm not gonna be able to hear all of you here. I can tell by the sign-up sheet where you check the box if you're for or against. The vast majority are in favor of this legislation. I don't ever like to cut off debate, but we have a limited number of days in our legislative session. And we really got about 48 hours left in the Senate to get bills out of committee if they're going to go to the floor. So to avoid killing the medical marijuana bill tomorrow or any other legislation, I'm going to have to kind of move on. If any of you have comments and you're sitting there about to bust at the seams that you really are disappointed you didn't get to share them, you are free to submit those by email in writing. My office is down the hall at 432. You can drop it off. You can email Ms. Cindy West at senate.ga.gov, and she can make sure that the committee members have them in their folders to review. I'm a reader. I'll be up tonight reading a lot of the documentation's been given to us, trying to formulate in my head kind of where the consensus might be, and I'll reach out to committee members as well to get some input and the sponsor of the bill before we go any further. Yasser Ali, I think I had you down the other day and today. Are you here today? Okay. I wanted to give you a chance. And Michael Mumpers, are you here? Couldn't be here today. Couldn't? Okay. Well, I'm sorry I couldn't get everybody. How about Reginald Reese? Reginald Reese here today? All right, well, I think I've done pretty good of hitting most of them. Then I do have James Hyman that I know was here the other day, and you're back today. Do you want to talk? Have at it. It's your go. What's your name again? Okay. Why are you pointing at him?
Because he got up to talk.
Okay, now it's your go if you want to. Don't feel obligated.
Good evening, Senators. I'm not a public speaker, and I don't want to try to ramble. I just wanted to talk about a few of the points that I put out there earlier, and I'll just give you a little briefing. Again, my name is James Hyman. I'm one of the partners of a conglomerate of vape shops called Peachtree Vapor. Peachtree Vapor's background is safety. We have a five-star, almost five-star Google rating. You can check the reviews for yourself. The company is also owned partly by an FDA-registered and OTC-certified lab, so we're aware of marketing and labeling, standard operating procedures. We only purchase from manufacturers that have C of A's, like we've discussed over and over, both last week and today. this ban, I don't really understand it. I don't know if it sounds more like a kid problem, and it keeps coming back to kids are getting a hold of it, and you have to be 21 to purchase these products, and if they're getting a hold of them, I don't know where they're getting a hold of them. I don't know if they're getting them from gas stations. I don't know if they're getting from someone on the streets. Everybody gets carded walking into a shop, in a vape shop. I think if there was some kind of parameter put in place with these products where your primary product you sell is that type of product, it will keep it out of maybe bad hands, whether it be gas stations. Someone mentioned it's going to be in Kroger or Publix. I've never seen it. I don't understand that. None of that makes sense to me. I just hear things that make my blood boil, but at the same time, I do want people to be safe. And having C of A's, having correct labeling, all that we're all in favor of. Delta 8 is about, per the research I've done, about a fourth the potency of Delta 9. We have many, many customers that use these products, and I will tell you, easily, average age, probably 40 to 45 years old. We don't have 21-year-old kids coming in to get high. If they want to get drunk and get high or whatever, they're going to find what they need to find. We have proper people coming in for fibromyalgia, for sleep issues, for anxiety. It's used properly. It is a great product, keeps people off pharmaceutical drugs that don't agree with them and they don't like. I think that's basically it. Just label the products, buy from correct companies with C of A's. It's always been 21 and up, so I don't understand when people say a 10-year-old can buy this or a 12-year-old can buy it. It doesn't happen. I haven't seen it. Keep it in the shops where people can talk to people and understand why they want it. We spend 20, 30 minutes with a customer. Somebody comes in with an ailment. We find out what the problem is. We start low. We will give them a product that we think works at a lower amount. They try it at the lower amount. They typically get an effect from it. If they need a little bit better effect to fix their malady, they can choose a little bit more. We're having amazing results from it. Teach the people how to use it. They're going to use it properly, and it's helping. That's really all I have to
We
say.
appreciate you being here. What's your name? Rick, come talk quick. Rick Height. You are against the bill.
Partially.
All right, tell us why.
So,
That's why I'm calling you to balance, give equal amounts.
well, I appreciate it. Yeah, thank you for taking the time to hear us. The gentleman, I'm sorry, Mr. Perkle, I think, yes? The guy who introduced the bill, the heart of the bill, as we've all been talking about, is consumer safety, right? And at our shop, I forgot to tell you guys who I am. So I have a line of CBD stores. We have 3 shops. From Atlanta to Alpharetta, all the way up into Dawsonville. It's a small company, about 15 people. And I'm surprised that I haven't heard anybody here mention this problem with the testing that's in the bill. Because we're asking for the product in the bill to be tested at the finished goods level, right? And you know, I want to draw like a little bit of a picture. So if I have a kilo of distillate, right, that comes from the raw plant, that's a million milligrams in weight. Right, that's what a kilogram is. It's 1,000,000 milligrams. So it's 1,000 milligrams times 1,000, or 1,000 grams times 1,000 milligrams. Right, at 90% concentration, that's 900,000 milligrams. You're making gummies that are 30 milligrams. You're getting 37,000 gummies out of a single kilo. So a kilo looks like this. You guys know about what a liter of Coke looks like, right? It's about that much. A 1,000 gummy bag is 11 pounds. You hold it like this. And you're making 37 of those bags. You're diluting this product down at such an incredible amount that testing for pesticides and solvents and all of this kind of stuff at that level is pointless. It really, it doesn't make sense. The test, the full panel test needs to be done immediately after extraction. When they make this product, it grows in the field, somewhere between 15 and maybe 25% is like active compounds. Then it's distilled down to a very concentrated form, usually over 90%. And then at that point, you do your solvent remediation, you pull out any of the stuff that's bad that's supposed to be in there, pesticides, any of that, and then you test that product. And if you get a result for pesticides on that lab report, a chromatogram looks like a little histogram, right? You could have a tiny little spike of pesticides or hexane or whatever the bad thing is that you're looking for in there. And I can do math. I know how much oil to add to that to crash it out of the report. And so we do all of our testing at the distillate level. And you know, we're horizontal. We don't control everything from seed to shelf. We go buy the distillate after the farmer's already done his thing, after the extractor's already done their thing. And then I go buy the kilo. I send it off to ACS Labs down in Florida for a test. And if it passes everything at that level, I know anything that I make with that, any co-packer that I use to produce a product, or anything that I put in the shelf on my shelf is not going to have any of those things in it because I've tested the precursor. This gives a way for you to hide things in that bill. So, you know, that's the reason that I'm opposed to it primarily. And I've got a few other points here if we've got time for them. But yeah, go ahead.
Back up. I wish I could hit rewind. What was that last comment? Why are you opposed?
Because this gives you a way to hide pesticides in a finished good. You're only asking for the product to be tested at the...
You'd rather it be tested at the
processing
level, distillate level?
Correct.
Okay.
Correct. Yeah.
All right. Gotcha.
Because, if you have a little bit that shows up and it meets like a little bit of pesticides or hexane or whatever, just because it's under the LOQ of the lab that's doing the testing doesn't mean that it's not in there. It just means you can't see it in the finished good. So
you are ATLRX?
Correct.
What is that?
It's a CBD shop, so we have...
So you're just a retailer?
Kind of. So
are you making the compounds yourself?
No, I'm not in the back stirring the kettle, but
do retailers do the kettle stirring, or is that all?
None that I'm aware of. No, it's all done through processors.
You were starting to talk about that, you made me think you were.
No, but I have to know all of that because
you were making making your own gummies.
No. I'm commissioning the gummies to be made though.
Okay.
So that's why I'm so familiar with this process, because I know what steps you have to take to get a product to market. And it's not that I have to make it, but I've got to be responsible in who I do business with so that I know that what I'm putting on my shelf is safe for my customers.
You mentioned getting your products tested in other labs. That's not required under Georgia law now, is it?
Not currently.
Okay, you're just doing that as a measure of customer service, so to speak?
That's
or to
correct.
Make sure?
Yeah, that's the way we think it should be done. We look out west and we see how they do things. We know those regs are coming this way. So, we're set up like
my star witness, Mr. Bush, the other day said he also is doing that. Is that fairly common in the industry that the retailers are having this third-party full panel testing independent labs?
With the reputable companies, yes.
Okay.
I can't speak for what you find at any corner store anywhere, but yeah, if you're...
Do you think you ought to have a license to sell these products?
I'm not opposed to it.
Okay.
If it's not cost prohibitive, I mean, we're a small business. If you made it $1 million, that's not going to work, but I mean, we're absolutely not opposed as a retailer, as a company, to obtaining a license with a reasonable fee associated with it. I think you've outlined in here $1,500 or $500. I would have no issue with that as an annual fee.
I didn't mean to cut you off, but
no.
You threw me a curve there. I couldn't comprehend you. All right, go ahead. You got a couple more points, and then we're going to have to wrap it up.
I do, yeah. And the other thing I haven't heard mentioned, and it's not in the bill, is child-resistant packaging. There's a whole industry around marijuana packaging out west, and we have them in our backyard here. There's a company I use over in Norcross that creates child-resistant pouches for these gummies. You can get opaque bottles that don't display the product, that you have to push down and turn, and we get complaints on it because adults can't open it. We get those calls in, and so if there's all this concern about this getting into the hands of kids, and nobody's mentioning the child-proof packaging, which is out there, and in our opinion should be a requirement, and we're doing that today, because at the end of the day, and it's about the product category, right? So if it's an edible, if it's a fruit flavored type of thing, then kids know how to eat that. A kid's not going to accidentally buy a bag of flour and accidentally roll it up and accidentally smoke it, but they may, if they have a gummy, accidentally eat it, right? And so putting
common sense kind of safeguards on those types of products, I think, are necessary. And, some of the other things, like, we can't go too far with that. I know some states will make you have to have the little zipper bag that has like 18 locks between you and the product inside. Bags cost the consumer $10 a piece, and those dispensaries aren't paying for that. They're passing it on to the consumer. So there's a certain reasonable level, I think, that we can take this, and it's stuff that we already do. Same thing with the labeling. Right on our bottles, every last one of them says not intended for use by children, not allowed for minors. Don't use if you're pregnant. Don't use if you're breastfeeding. It's all right there on that label with the QR code that doesn't take you to a lab page where you got to sift through batch numbers. It takes you to the actual lab report for that product, and that's the way it should be. And you have, a lot of variance in this industry because it is not yet standardized. But if we look out to some of the other states that are around us and out west, these are the things that they've already figured out. They've already done this. And, to be ahead of the curve, that's what we've done as a company, is gone in and made those things a reality today. When you come into my shop, there's a big wall with a 600-pound mag lock on the front door. You can't just walk in. You come up and you show an ID, and if you don't pass the age check, sorry, take a hike. So we're doing that kind of stuff today, and that's the way that it should be done. And I think that, that age part, no issue. The other thing that I have a problem with, and I'm trying to be quick, you can tell, is the definition of hemp. If we get out of lockstep with the federal guidelines as far as what the definition of hemp is, it could potentially kill interstate commerce, which would put me out of business, because we buy a lot of our products from Oregon, California, Colorado, because Georgia is just not mature in that area yet. There's not a lot of Georgia farms. The gentleman that came up here earlier said he's the only processor in town. So, I mean,
would you be able to sell those products if they all had to be tested to the Georgia Department of Agriculture lab? From all those other states?
Well, no, it's really more the definition of it, about the compounds that have to be in there. So, for us to change anything about that definition, which is what all the other states that haven't gone in and changed their own or made their own legislation against this, then everybody's on the same playing field. So your interstate commerce can be fair. So Georgia-grown hemp can be exported to states that share that definition. Other states' hemp can be imported into Georgia to create competition, which benefits me as a horizontally integrated person or a company, because I can now go and I can find the actual best product out there to bring into my shop and serve to the consumers. So that's my concern with the bill there. The milligram limits, we've beaten that one to death. The only one thing I want to add to that is the fact that it'll kill flower sales and vape sales. Well, vapes, you could get away with doing a 0.5 ml cartridge, but people are just going to buy 2, so I don't see a point to it. Flower can range between 20 and 45% active cannabinoid content, right? So 1 gram of flower is 1,000 milligrams in weight. If it's 40%, that's 400 milligrams in one gram of flower. So customers that want to come in and buy 7, they're now given 7 packages, right? They're still going to buy it. You haven't told them they can't buy it in here, but they're going to buy 7 packages. That makes my packaging costs go up by 7-fold. That makes their cost go up, because I'm obviously going to be passing that along to them. That's how business works. So, I don't see any point in those, and I'll just leave it at that.
I think I'm going to have to wrap you up right now then. You good? You wanted the last one?
Can I do one more?
You can.
All right, I got one more for you. So let me pick a good one here. So we went through all that. So yes, COA labeling, age resistance, child resistant packages, got to have it. The other thing Sebastian said on Thursday, I wanted to clear that up, because you guys all kind of gasped when he said there's over 90 compounds that are psychoactive. Caffeine is psychoactive. Psychoactive just means that it affects the mind in some way. It doesn't necessarily equate to get you high, and that's, I think, an important distinction to make, because I felt like he was discussing it from a very scientific, technical standpoint, using the word psychoactive appropriately, but colloquially, psychoactive means get you high. And I just wanted to clear that up, because there's not, as far as I know, there's not 90 compounds in there that you can use for that purpose.
Do Delta 8 products get you high?
It depends on how much you take. Again, that's it's like anything else. You have 1 beer and you're good to go. You have 8 and maybe not so much. So it just depends on responsible consumption and how the user uses it. And to the gentleman that mentioned the 2-year-old, I wanted to know if that 2-year-old died. I mean, I figured you would have picked an example.
Well, we're not questioning him now.
Well, that's fair, but I figured he would have picked an example of death as his worst case, and so I wanted to, that's an issue of parental oversight, child-proof packaging, and just responsible handling and use of these materials. So that, I'll leave it at that. I appreciate your time. Did anyone over there have questions about any of that stuff? I know I kind of rambled on because I know we're getting short on time, but.
Questions, thank you.
Fair enough.
Drew Hull, would you like to be heard? I know you traveled to get here. You're not on the spot. You don't have to be here. And Joseph McCormick, y'all were. Yeah, you'll be like, ma'am, what's your name? Yolanda Bennett. All right, Ms. Bennett, you're the last one.
Committee, thanks for giving me time. My name's Drew Hull. I'm from a company called True Terpenes. We're a key ingredient supplier throughout the hemp industry, as well as servicing the recreational cannabis industry throughout the United States and in several international economies that have hemp as well. I work as product formulations, and I've had the privilege of working with very large brands throughout this hemp space and seeing this space grow over a decade as the distillates and formats have changed. And I want to be clear that I really do encourage clear regulations, but the language in the current bill is unclear as far as I'm reading it, and I think it would confuse a lot of product producers, processors, and farmers and create undue burdens on them. For example, we've repeatedly referenced isomers throughout this committee meeting, and it's not clear to me exactly what the intention of that language is, as well as how it should be interpreted when something like CBD is, by technicality, an isomer of THC. And I think that these things are very flippant with the organic chemistry that requires a high sensitivity and a big knowledge of chemistry in order to execute correctly, as well as the difference and similarities between molecules not necessarily indicating a similarity of effect or use case. Again, the same criticism applies to the use of the word esters, which is a relatively broad category, which I understand the intention is to limit intoxicating materials, but this chemical language does not necessarily do that in terms of how a processor should interpret it and what distillates they're making. As well, the list of solvents that's been proposed here seems extremely aggressive as far as any solvent standards. In terms of consumer safety, it's difficult to understand why 29-fold hexane difference between 290 ppm versus 10 would be proposed. And I don't know if there's any toxicological motivation that I've read before or seen other manufacturers deal with in terms of those high limits. It seems that it would create difficulty for interstate commerce more than ensuring consumer safety by any standard. We agree that, I definitely agree that it's important that regulations allow Delta-8 to continue in the market, as this is going to have a huge economic impact if the Delta-8 were to be banned completely. It's key to the success of the farmers in the hemp industry, as it's been a major economic outlet for the flower. For extractors, it's one of the key materials that they are producing, and for the shops, I know it drives a huge portion of the sales of the products that people consider therapeutic. It's also important, I consider, to adult freedoms, as many people are using these for therapeutics for different reasons, and not with the explicit intention to get high, and in many circumstances as an alternative to the things that got them high before or that they are trying to get away from. Such as life difficulties, even non-substance abuse things like PTSD or fibromyalgia.
Thank you.
Clear regulations should include packaging and labeling requirements, limitations, and age restrictions. And I think everyone that I've met in the large processing side of the industry could get extremely behind those and considers those extremely sensible, while the more detailed analysis of the chemistry that's been proposed here creates difficult to understand standards that do not necessarily lead to a clear outcome where consumer safety is centered. Thank you for your time. I really appreciate it.
Thank you. Yolanda? No. Come on up. Yolanda, go ahead. Come up here. Come sit on the front row. No, ma'am. Go to that podium. I'm speaking to another gentleman back there. That's good.
Good evening. I appreciate you all allowing me to speak. Briefly, my name is Yolanda Bennett, and I am the co-founder and operations manager of the Georgia Medical Cannabis Society. We are a 501c3 nonprofit organization that has been assisting patients with navigating through Georgia's low-dose THC program since 2019. Our main goal is to ensure that underserved communities, low-income veterans, disabled, and previously incarcerated persons have access to affordable cannabis and medical cannabis cards in accordance to the prospective state laws. We believe in patients over profits. In the previous hearing, and also this hearing, refers to patients visiting emergency rooms and urgent care over consumption of hemp and from derived THC. The issue is due to lack of knowledge about the product. Hosea 4:6 says, "My people are destroyed for lack of knowledge." Many people don't understand how to use the product. So this could be the reason why so many people find themselves in the emergency department. So instead of putting the blame on the product, place it on the lack of knowledge. Place it on the lack of knowledge. Classes or materials and instruction should be available for the consumer if a vendor sells the hemp products. Can I go on? I got just a little bit more. Oh, that's it. Okay. Oh. Oh, yeah, I'll be back tomorrow. I'll be back tomorrow for 196. I can, like I say, but I just wanted to let you all know that the reason, are those CBD gummies or they're THC? Only reason why I was asking is because...
We had a comedian on our committee that thought that'd be funny.
Okay, I got you. The only reason why...
It wasn't funny.
The reason why I asked, because I was very concerned as far as how you all were ingesting, because I already, because I was concerned because I was like, that's why I said the lack of knowledge.
No.
2 packs, I got you. Okay,
We're
so
scared to death after all this testimony. Might never taste it.
that's right. Like,
What is your name?
okay.
You got something unique and complex you want to tell us? Come on. Because our last bill dealt with those 2 words, complex and unique. All right. I'm going to give you about a minute and a half or 2 minutes because...
I'm going to read really, really fast then. Hello, my name is Sammy Moore. I'd like to start by thanking the committee for your time. I'm the owner of Cloud9 Smoke Company. Yes, my schedule is unique and extensive. And I cleared it to be here today. And this is very important to our industry. Cloud9 has over 50 retail locations across Tennessee, Florida, and of course the majority of the locations are in Georgia. We currently employ over 400 employees with a payroll that is 7 figures a month. Our business did over $48 million in revenue last year and over $12 million in hemp products alone. Between the taxes, sales tax, payroll tax, tobacco tax, income tax, and vapor tax that includes hemp products was over 8 figures that I paid last year. This bill would eliminate half the workforce and the taxes we pay for this state overnight. Our business has grown substantially the last few years. We attribute our growth to focusing on taking care of our employees, mentoring them on skill development, and giving them opportunities to one day own their own franchises. We currently have 8 franchise locations who also each contribute to the employment, payroll, sales, tobacco, and taxes to the state. Last week I heard the committee members ask which state has put regulations around this product. I looked into it myself, and we can take a look at our neighboring state, Florida, for example. Florida is part of the 11th Circuit with Georgia. Florida also regulates hemp products through the Department of Agriculture, but unlike this bill at hand, Florida does not specify a limit for the amount of milligrams on hemp product packaging. It has worked very well and been very successful for them. We can mirror Florida's bill by taking out the limitations of hemp milligrams without issue. That Florida law is 581.2177. If the 500 milligram limit is imposed, the customers will just buy more. The cost of acquiring the merchandise will just go up for the end consumer. Furthermore, there are several other products that will be eliminated from the market entirely. Lotions, creams, etc. That simply cannot be manufactured at a lower milligram to effectively help the customer. The best solution is to take out the milligram just as Florida did. Similar to this, Florida Department of Agriculture currently issues licenses to retail hemp establishments, which I believe is a great idea as well. To keep something like that in the bill, to ensure the proper and equal regulations of businesses who sell hemp in the state. We saw in the bill that there was going to be a minimum age of 21 to purchase the hemp products. At our establishment, our minimum age is 21 years old, regardless of what products you're buying. It's not that the product is bad, but just like other over-the-counter flu medicines, video games, and even tanning salons, some have age requirements because the requirements in place, and the business abides by that no problem. Requiring lab testing, a passing COA is great, but having a 12-month span on the COA will be problematic and impractical for retailers to keep up with. Currently, the bill requires a manufacturer to have a COA done in the last 12 months of the product. The problem with the language is that the product shelf life is typically longer than 12 months. This language put unreasonable requirements on retailers to audit the product and send back to the manufacturers every 12 months to get a new COA. Thank you, and I appreciate all your time and consideration.
Thank you, and thank you for your patience for hanging in here. All of you, we appreciate your citizen input. Hey, baby, we'll see you tomorrow. We can't hear from every single one of our 11 million citizens in Georgia, but your input is invaluable in this process. To my committee members, thank you for being so strong and durable to hang in here with us this long. It's not often that we demand this much of you, but I appreciate your diligence. You're doing your job. And the honeybee may fall out over there if we ain't careful. But Chairman Perkle, thank you. I know a lot of time and effort. I will meet with you tomorrow. Tomorrow we're going to hear House Bill 196. That's on cannabis licensing. Will be 10 to 12. Same thing on Thursday, if needed, will be 10 to 12. Try to reach some resolution on both of these bills. They're not really interconnected, but boy, they're sure similar when it's the same plant, pretty much, what we can tell. Senator, you got a comment before we wrap up?
Yes, sir. Thank you, Mr. Chairman. I know you asked our professional educator to come back, Mr. Bush. Did you need anything from him for this bill, or was this you need him for Tuesday, tomorrow?
I was just saying he was one of the best witnesses we ever had, and he had signed up again today.
Okay.
And I love having his expertise to share with us. He taught this committee a lot, and I feel like that's our job, is to try to learn a lot of different subject matters so we can make sound policy judgment decisions.
Absolutely.
One good thing is it's a 2-year biennial. Sometimes bills take more than 1 year studying to get them right. And
That's right.
Having the two bodies irons out difficulties as well, and we'll see what we can do with these.
Thank you.
Yeah, there was a couple people that looked like you're agitated you didn't get heard. Just hang around, come up here and talk to me afterwards, and I'll let you know if we can talk to you tomorrow, get something in writing to put in our files before we make decisions. With that, everybody have a good evening. We are adjourned.